Hey everybody, today is October 18th, 2023. I'm Gene, and welcome to the Wednesday edition of Hanging with Uncle. Before we get started, you know the routine, please hit that subscribe button if you have not. We're really trying to grow our channel. Help us get to over 100 subscribers. And also hit that like button, it's that thumbs up, it really helps spread the word out on our channel. And that notification bell on the far right lets you know when we go live and put new content out. So having said that, let's kind of get into it because we have a couple of topics today just to kind of let you know. Number one, deregulations, scaling back government authority, and qualified immunity. So let's bring our man on the street into the conversation, Brent Naple. Welcome to the show, Brent.
Hey, thanks for having me again, Gene. Well, we got a lot to talk about, man. There's been a lot of stuff going on in the news. I'm at war, people arguing who's going to take over the hot seat there in Congress. Is it going to be Jim Jordan? Who's going to win? So we got qualified immunity being it's going to be brought up in one point of it in the Supreme Court with another case, and then the scale back of the power of federal agencies. So this is right up your wheelhouse, man. You're the law guy, and you're a police officer, and this is qualified immunity, so cops can't be sued, or can they?
Well, so qualified immunity protects them from civil lawsuits. As long as you're acting within the course and scope of your duty, you are protected from personally being sued. So in other words, nobody can take your home, your assets, your bank accounts, things like that. That's what qualified immunity protects you from. And on the other one, I went to law school. I'm a law school graduate. I'm not an attorney, but for 4 years, that's what we did. We read cases, dissected them, picked out the legal issues that the courts were deciding, and that's my background and where I come from with the conversations that we're going to be having today.
Yeah, man, I know the law, of course, from the other side of the courtroom a lot, but I'm glad that, glad that you're looking at this right now, but the timing of it is very, suspicious to me. So we've been talking a lot about chaos and chaos brewing. There's a lot of things in this language where I'm worried about how that will affect us as we go into election season too. So why don't you want to start with the qualified immunity and let people actually kind of know what the case is and how it was, how it's going to be brought up to the higher courts.
So the qualified immunity case is Sylvia Gonzalez versus the mayor of Castle Hills, Ed Trevino, his chief of police, John Siemens, and let's see, he was also sued in his individual capacity, which brings up the qualified immunity issue. So with that case, basically in the lower courts, it held that qualified immunity did not apply, and that the defendants in this case were going to be held accountable for their actions. And basically, Ms. Gonzalez was saying some things about the city manager, which are her rights under the First Amendment, and they took offense to it. I guess, long story short, she wound up with a document she wasn't supposed to have, apologized, returned it, and they used that as the basis to want to interview her, the police to interview her, interrogate her, which she denied. She said, no, I don't want to talk to you, I don't have to. Fifth Amendment right against self-incrimination, in my opinion. But the police chief took that as a sign of obstructing justice and obtained a search warrant, and the rest is history. And basically the appeals court of West Texas said that qualified immunity definitely applied because the police chief was acting within the course and scope of his duty and legally obtained the search warrant. And I don't know, to me, I just want to know your opinion, man. If you think that's a good old boy ruling, or if you think that it's done in retaliation and they're trying to silence Miss Gonzalez.
Well, it seems like there has been a lot of documents been taken home recently. A couple of presidents recently been in the news over this, but they didn't get thrown into a jail with a jumpsuit on for it. So that's just like, for me, I kind of feel like, well, did she take it in by accident? And then what was the paperwork she did take? Like, I remember there was a case in, I think, Colorado, that the lady that runs the election office was taking information from the election office home. Now, so when you get down to it too, the lady is like 67 years old. She looks like anybody's grandma on earth.
That was Tina Peters, I believe.
What, the lady from Colorado, right?
Yeah.
Yeah, so I didn't know. I don't know even what happened with that. I know the president's got off. I think she got off. The only thing that happened to her is she got where she can't be the election official anymore.
I know she got more sanctioned than jail time. I don't think she got any jail time, but I don't think she's allowed to vote or be around any voting apparatuses or anything. She can't participate in the process anymore.
So it looks like they were trying to humiliate this lady by putting her into an orange jumpsuit, having her go through the whole process, holding her in jail. That was, that does seem to be a little bit on the line of retaliation. Now, whether that was or not, the thing that happened in the appeal court bit, didn't they say something like the language was to pass it up? They said there might have been some problem with the police too.
So let me find that page.
Yeah, because I think that was the point that they're going to try to argue when it goes to probably to the Washington appeal court.
Yeah.
But
so it says, the district court's denial of a claim of qualified immunity to the extent that it turns on an issue of law is an appealable final decision within the meaning of 28 U.S.C. Section 1291, notwithstanding the absence of a final judgment. Accordingly, under the collateral order doctrine, we have jurisdiction to review this interlocutory appeal of the district court's denial of qualified immunity. And then they go on stating, Kelson v. Clark, that we must accept all well-pleaded facts as true, draw reasonable inferences in favor of non-moving party, and the complaint must sustain sufficient facts to allow the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. But the complaint's naked assertions, devoid of further factual enhancement, will not suffice, and the courts are not bound to accept as true a legal conclusion couched as factual allegation. So basically what it sounds like to me is the appellate court is throwing this case out based on you're just making an allegation that this is a retaliatory arrest and you have no facts to back it up. Which to me again is BS, because we've been through Texas before, and when a woman sues 3 men, we kind of know what she's going to be up against.
Yeah, there is a certain system in Texas that is, I guess you don't mess with Texas or their, or a couple things with them. They don't like to, a lot of cops, I think, are according to their environment and the police around them and the judges, they feel a certain ability to go ahead and dictate law according to what they see, what they can get away with sometimes, instead of reading what the letter of the law is. Now, this doesn't happen everywhere. I mean, there's lots of good police out there, but it seems like it just seems like there's a lot of stuff going on in Texas that is kind of confusing when it comes to the courts. I mean, even how they handled the school shooting down there with the Uvalde case. And that it just is, it just seems like a lot of things could be, maybe better training is needed to go ahead and get everybody online so that there's consistency throughout the whole Texas, the whole Texas police force, that there is accountability and continuity to it, but if this gets passed up, which it would go to a higher court, then this is why the Supreme Court is maybe picking this up then.
Maybe.
Now, they're already one of that.
I don't have the facts of the case brought before the trial court to see if the burden of proof was met that the arrest and search warrant were based on retaliation and not the rule of law. Because if you're making that assertion, you have to prove that assertion beyond a reasonable doubt to 12 people in the jury. And that's a piece of information that I am missing right now, but that's another piece that I think that they would have to have nailed down solid, before they go in front of the Supreme Court with this argument.
Well, after talking to you for the last year, I should get a Cracker Jack a law degree or something, man. It's just incredible. I thought I knew law and all that, and then just all this stuff has been going on in the last year. I've been trying to study, and then, man, and then there's so much ambiguity, and then it going back and forth, and so. What do you think about, do you want to move on to the next one, or you got anything to add more to qualified immunity?
On this one, again, all I can say is the burden is on the people or the plaintiff, and that's Ms. Gonzalez, number one. The questions that I would bring before the Supreme Court, number one, was her burden of proof met proving her allegation that her arrest was retaliatory and not based in law. Because if it's not based in law, if the appellate court here is wrong and it's not based in law, then the Supreme Court can overturn it and strip qualified immunity as a defense from this case. So that's going to be their burden they're going to have to prove, and that hurdle they're going to have to overcome at the Supreme Court, and it's not going to be an easy one. So that's all I have to say on that case on qualified immunity. In my opinion, I was actually sued once when I was working undercover, and
okay.
It was that was basically their argument that I was not acting under the color of authority, that the warrant was bogus, and long story short, it was upheld by the California Appellate Court, and the warrant was valid. But yeah, so I was actually sued one time based on a search warrant that I wrote.
Wow. Yeah, this could affect so many different levels. If we're gonna be giving out, that qualified immunity, that could really help good police forces protect your officers from good lawyers, basically arguing cases in court. So the burden of proof in a civil trial goes way down than a civil trial. I meant a criminal trial.
It does. So the only difference, really, the difference in a civil and a criminal trial is that in a criminal trial, you have the Fifth Amendment right to not say anything, and it cannot be used against you. Versus a civil trial, if you take the Fifth Amendment, then the jury is given instructions to infer your guilt for not wanting to be forthcoming with the questions that are put before you. So that's really the only difference going civil and criminal. But the one thing consistent in the two jurisdictions is that the burden of proof is always on the plaintiff being the civil case and the people being a criminal case.
Didn't you bring up something about the Fifth Amendment too, about the qualified immunity?
In my readings, I didn't see so. I just thought, my reading was that it should have been written better. And a lot of times, you'll hear complaints about it. I'm not trying to get sidetracked. Oh, we arrested this guy and he's right back on the street. Well, 9 times out of 10, read the report that the cop wrote. If it's full of holes, then of course that the prosecutor's not going to bring that to court, because they only want slam dunks. They want their conviction rate to be like 99%, and they're not going to bring a case that's full of holes and be laughed out of court and have their credibility looked at negatively by the judge. So that's what I would say. Cops just need to learn what the elements of crimes are, document them appropriately and effectively in reports, and you might see less people getting kicked out on the streets and not being prosecuted.
Yeah, too bad it wasn't about the win as much, So, if the prosecutors are worried about basically advancing their career, they're looking at going to the other side, basically using which a lot of them do. They're prosecutors first, almost all of them, or the high profile ones, and they finally go to the other side. But it should be about trying to establish rule of law more than padding your profile. I don't know.
Well, we have to get moving, but just so people understand really the criminal justice system, the district attorney's office and the public defender's office is an assembly line.
Yes.
9 times out of 10, the prosecutor's always going to work to get a deal, and the defense side is always going to look to get a deal, or have it dismissed, or offer something up to give up a bigger fish. Always something to get their client off, just to clear the paper, because they're very overworked and very underpaid. And that's all I'm going to say about that. So that's just how the office works, man.
Yeah, no, that's exactly right. There it is, and they got so many cases, man. They got so many cases they're going through, and almost everything that happens when they talk to each other behind closed doors.
Yeah,
So they're trying to move it through, being efficient, which saves taxpayers money basically. But so the next thing we're going to go to is to scale back the power of federal agencies and basically deregulation.
Yes.
So you want to say something about that?
No, well, go ahead, man. I'll let you go ahead and you preface us with the facts this time.
Okay, man. So basically, Contasia Brown Jackson was involved in a case, actually talking about this in the past. So she's going to be actually not able to sit in on the one point they're going to bring up in this case. So if they're actually going after what I look at as a separation of powers more, like they're going to go ahead and if this is a case, the case to bring up is to do with marine fisheries. So it's going to be on a case that's already being tried, but they're going to argue one point about this, about the scale back of powers of federal agencies too. So they're basically going to kind of combo or bundle and save in a way. But if Jackson Brown isn't part of the process, if Brown is down, basically this is going to be more of a conservative point to help out big business, I believe.
Oh, without a doubt. So I know you want to look at it as a separation of powers issue, but to me it's more of a deregulation issue, because separation of powers is what Jim Jordan is trying to do, like in Alvin Bragg's case, in Fani Willis's case, where he's trying to use his congressional office to, overreach into state criminal jurisdiction, which they don't have, because the states under the 10th Amendment have the right to govern themselves. So therefore, by Jim Jordan trying to, tell Fani Willis and Alvin Bragg, give me your information, give me your evidence, that is a separation of powers, because he's overreaching the power that he has. In this case, it's more deregulation of government, taking power away from government, and giving it to big business and corporation. And that is where I think, even though the court's at 6-3, losing Justice Jackson on this is really not going to help at all, just because she was involved in this same case in a lower case decision before she was elevated to the Supreme Court.
Yeah, I kind of feel like they're setting it up for later on down the road. So they might argue this right now, but we have the Senate is actually in Democratic control, so I don't see the Speaker actually letting this go through, at least right now. But what this could be used for is a rallying cry for the election season coming up. So they're going to be using this to go ahead and basically get campaign contributions. This is like a hot point. This is a hot point for years about what, how much regulation do we need? What do we have to do to deregulate it? Blah, blah, blah. But if you're looking at it from the fisherman's point of view, which I know a lot about this because I was involved with the Wild Fish Conservancy case this summer. And this had to do with basically with the marine fisheries that this case is being argued through. So the National Marine Fisheries Service, they have regulators on board big trawlers. Sometimes they get on the smaller little trawler, the smaller set netters, or they go from one set netter to another, and they got to charge a fee because it's a service. So they go through and they go ahead and make they hold everybody accountable all the way throughout the whole fishery. So the thing is, for years, is these trawlers, these bigger ones, which are making a ton of cash, they've been trying to get rid of the regulation on there. And there's a thing that happens that is called bycatch. So bycatch, there's been a lot of king salmon that have been diminishing. The state of Alaska, the state of Alaska Fish and Game, they're saying 3 different things. All the experts say different things. It's environmental reasons. It's overpredation. It's the mismanagement, on this or that end. They've been pointing fingers at each other, but never really, the fishery keeps on going down and down. So the river I worked on in Alaska was affected by this bycatch greatly. And the numbers kept on going down, where now the whole king salmon fishery is basically shut down. So by having these regulators on these trawlers and boats, this actually would help out. So by taking them away, this would ledge the game to big business, to big fish, I call it.
Yeah.
And they're basically trying to buy up and get rid of the smaller vessels and control the whole game. Even how the Wild Fish Conservancy is saying is they want to support salmon, but they also want to support orcas. And there is a pod that is going down, blah, blah, blah. But this is getting to another story.
Tell me if I have this right, Brent, because I'm kind of slow sometimes, but it seems like they want to deregulate, take authority away from the government, so basically they can act like mom and dad aren't home and there's a party at my house.
Yep. Yeah, the party is, on that, we go to the wiener and beans party and they're eating caviar.
Yeah.
And it keeps on going back. I actually just talked to the guy that runs the Bristol Bay Fishery. So he's the Fishery Association thing. They just got awarded money for their to buy salmon. The USDA just said, hey, we're going to go in and purchase so much fish off you. I think they're going to purchase $67 million worth of red salmon off of Alaska. But the thing is, it isn't going through Alaska, it's going through Trident Fisheries. So Trident Fisheries already have the largest stake in the trawler business and every aspect of the fishery. So by awarding them the money, you're actually creating them to have a little bit more leverage in a way. To go ahead and help the smaller fishermen to keep their price down. But now the USDA is saying, hey, we can only buy, I thought they could buy anywhere on the world market. No, it has to be, in a certain market appropriate for each sector, blah, blah, blah. It's a long story. But the thing is when they go in and buy fish off the small guy, they're using the global price. They're not using the price for what the Alaska market is. So this whole thing could affect just not the fisheries. This is going to affect climate change. So the EPA won't have their authority more. So deregulation again. The oil people will have free reign to do whatever they want and dirty up everything. This will affect immigration, labor conditions, and public health. And with immigration, they're worried about building walls everywhere. But by them defunding the ability for Custom and Border Patrol to do their job correctly, how is this actually helping keep America safe? How can we make America great again if we can't even keep it safe to begin with?
Here's a question on this deregulation issue, is that they want to consider the Chevron versus Natural Resources Defense Council that set forward the factors to determine when courts should defer a government agency's interpretation of the law. So, yeah, basically depending upon who's in power, we can play a good old boy system, because in 84 case, this is Reagan. This was all about deregulation, and this was, how much are you going to pay me to give you this contract and this bid? And that's when the government gets to turn a blind eye and decide that that is the interpretation of the law. And that's the effect of deregulation, and it gives us all the effects that you just described.
Man, I don't know what, like I said, if they're arguing points of both these, the qualified immunity and the scale back of powers, it seems like they're setting this up for pushing it down the road. And by arguing points, what happens is, when Congress is hearing this, they're the ones that can enact laws. So I knew, this happens on the Democratic side too, but Alito is very big on helping make sure that laws are written ambiguous enough or straight enough, basically, to go ahead and get done what he's paying, to get done his agenda. Of course, the man that's from brings about the Federalist Society.
Yeah. Well, unfortunately, we're kind of running over time for this week, so basically, pay attention to what's going on, people. Know what your rights are, know what you're voting for, and know what the effects of deregulation are, because these are the issues that are going before the Supreme Court, and we already know that Clarence Thomas and Sam Alito go on these lavish vacations with these people who have interest in these cases. So pay attention to what's going on. Again, our thanks to our man on the street, Brent Naple. Brent, thanks for being on the show with us today.
Yeah, thanks for having me, man. It's always great talking with you, and hopefully our message will help people understand the legal process and all the challenges that are in front of us. Vote with your mind, study everything.
Yeah.
Just don't be the sheep. There's too many lists out there right now, man.
Amen.
Learn, read.
All right, well, that's it. All right, well, that's all the time we have for tonight. Be kind to one another, be safe, and treat each other the way you would like to be treated. So Zane and I look forward to seeing you on Friday. Good night, and until then.